Dear students, so this is a new lecture on the field of the private international law. Well, in the previous lecture, we were talking about the sources of the international law, private international law. We were talking about the treaties as the first source of international law. I told you before that treaties are considered like sources for international law, public international law. However, it may be considered also as one of the main sources of private international law simply because they affect the the national laws, the nationality laws that are promulgated by the legislator inside the state. And I told you that there is a direct effect or indirect effect according to the concept that the state adopts within its constitution, whether the monism or even the dualism. And I illustrated that, not in a nutshell, actually, I illustrated it so precisely. And now, inshallah, we will move to another source of private international law, which is the custom and the other sources. However, I would like to illustrate something before getting to these points. Okay, as shown here, I started with the treaties and I told you what is the direct effect and the indirect effect of these treaties. And I gave you examples for the multilateral treaties which affect um, the international private international law subject matters, and the bilateral treaties like these ones are shown here, the Albanian treaties between the US and Albania, the also this treaty between Philippines and the United States regarding the consular relations, and also the multilateral treaties here which affect actually the private international law matters. And I gave you many examples, inter alia the Riyadh Agreement, the Vienna Convention Diplomatic Relations 1961, and the Havana Agreement or the post-Manti group. Now, the matter that I'd like to illustrate here before getting to the custom and the other sources is the international law uh, in confrontation with the national legislation. Like, what happens when there is an international treaty and national legislation? One of them is promulgated previous to the latter one. So which one of these treaty or national legislation shall apply in this case? Well, since private international law has internal sources like legislation, as I told you before, it may happen that the private international treaty contradicts with the legislation of the state. So what happens in this case? Like, there is a legislation regarding nationality and there is a treaty regarding nationality which the state is part of or a party to. So in this case, the question here, if there is contradiction between the private international law treaty and the national law regarding private international law, what happens in this case? Well, before discussing such assumption, we have to make sure that the treaty is applicable at the national level. And this actually depends on the criteria or the concept of the monism or the dualism that the state adopts, as I told you before. So we have to seek the constitution of the state to say what kind of concepts regarding the relation of between the national law and the international law that the state adopts or the constitution adopts, whether it is monism or dualism. Because in the US, for example, the treaty is ipso facto applicable after the ratification because it adopts the monism principle, while it's obscuri applicable in the UK since it adopts the dualism system. Okay, so in the US and France, for example, they adopt the monism concept. That's why the treaty, when it is ratified by the state, it is part of the legal regime inside the state immediately, ipso facto. However, ipso iure, the state has to promulgate a law which adopts this treaty in order to validate this treaty inside the legal system. Okay, so this is the difference between the ipso iure and the ipso facto effect. Okay, generally, international judiciary finds that priority shall be given to treaties over internal legislation. Okay, and this is shown actually in the ruling of the Permanent Court of International Justice. Please find these two decisions, 1930 and 1932. If you read the judgment issued in this year and this year, you will find that the court rules that the international treaty is given priority over the national laws and legislations. However, the question here, regardless of this fact that the international treaty shall be given like priority, does it make difference if the treaty came into force before the or after the legislation? Like, let me give you an example. The state issued the legislation, a national legislation, which regulates a matter of private international law. Then after this promulgation, the state ratifies an international treaties or any international treaty. Then the international treaty here, if it contradicts with the legislation which is found previously, which one of these laws shall be applied, the international one or the national one? Let me give you another example, which is the opposite. Now, the state is a party to a treaty, then it promulgates, after this ratification to this treaty, it promulgates a law, which is a national one, regarding the same subject matter of private international law that the treaty ratified before regulates. Then in this case, which one of these laws shall be given priority in application? Well, the question here depends on the scenario that we are talking about. The first scenario is that the treaty comes into force after the legislation was issued. So which one of these is previous to the latter? It is the legislation. It came first, then the treaty came later. In this case, we can consider that the treaty implicitly abolished the international legislation. لأنه في قاعدة بتقول إنه lex priori derogate lex posteriori، إنه اللاحق بينسخ السابق. فرغبة الدولة بما أنه انضمت إلى معاهدة وهي تعلم بأن هذه المعاهدة تتناقض مع التشريع الداخلي، إذا تكون قد اتجهت إرادتها إلى نسخ ما يوجد في التشريع الداخلي. Okay? The second scenario is that the treaty comes into force before the legislation was issued. Then it may that the state says here, well, okay, we find that applying the treaty would violate our national law. That's why we do not want to abide by the international treaty. Well, actually, this is not acceptable simply because the Vienna Convention on the Law of Treaties under Article 27, it says that a party may not invoke the provisions of its internal laws as a justification or a pretext for its failure to perform a treaty. احنا قلنا لا يمكن للدولة أنه تتذرع بأنه لا يمكنها تطبيق المعاهدة بحجة أنه ولا تتعارض مع أنظمتنا وقوانيننا الداخلية. وحكينا أنه هذا الجزاء اللي تبنته اتفاقية فيينا مفاده أنه الدولة لا يمكن لها أن تحتج بأنه لا يمكنها أن تطبق الاتفاقية لأنها تخالف قواعد الداخلية. كان مفترض عليك to foresee the effects of your ratification because your ratification will make this treaty obligatory to your state. That's why the international treaty shall be applied regardless to the fact that your national laws are violated if you validate such treaty. Okay, so in these two scenarios, the international treaty is given priority. So it doesn't make difference whether the treaty comes into force before the legislation was promulgated or even after the legislation was promulgated. Okay, so this is the uh, this is regarding my question whether does it make difference if the legislation or the treaty came into force before or after the legislation. Okay, now let we move to the second source of private international law, and the question here is, what is this source? It is the custom, and the custom is one of the main sources of private international law. So some jurists actually deny that the custom is a source of private international law. However, the majority of private international law accept this source as one of the private international law sources. Let me give you an example for rules of private international law that they are taken from the custom or they are derived from the custom, and they are still applied all over the world as customary rule, and it is not even codified in the private international law documents. Okay, so as an example for the customs as source for private international law, we have the rule which is the Lucas Regit Actum. What does that mean? It means that the place rules the act. The place rules the act. يعني المحل أو المكان هو اللي بيحكم، أو قانون المكان هو اللي بيحكم المعاملة أو بيحكم التصرف. لوكاس معناتها المكان، rigid regulates، the actum يعني التصرف. إيش يعني؟ يعني لما يكون في عندي واحد سوداني أبرم اتفاق مع واحد فلسطيني، عقد معين أبرموه في لبنان، وين محل إبرام العقد أو بنسميه لوكاس كونتراكتوس. خلينا أكتبها كمصطلح لاتيني. أنا بحب الطالب يكون ملم بهذه المصطلحات لأنه كثير بالكتب بيكونوا متداولينها دون أن يعطيها even an English equivalent. So لوكاس كونتراكتوس يعني محل العقد، محل إبرام العقد. So if the Lucas Contractus is Lebanon, then the Lebanese law shall regulate the matter here. Yani I know there is a conflict of laws in this case, a conflict of jurisdiction in this case, because the parties belong to different nationalities. However, regardless of their nationality, we have to look to seek the place where these parties concluded their agreement. Since the agreement is concluded in Egypt, then the law shall regulate this matter, even if there is a conflict of law or conflict of jurisdictions because as matters of private international law. The law that shall apply to this case is, or to this contract is, the Lebanese law. What makes me say that the Lebanese law shall apply in this case? Because it is the place where the contract was concluded. So the law of the place shall rule the matter here. The law of the place, I mean the Lebanese law, shall regulate the matter, which is the contract. That's why we say that the Lucas Regit Actum as rule, it is one of the main rules in private international law, which solves the problem of conflict of laws. It is a customary rule. You will not find it in any document of private international law, whether national or internationally, but it is adopted as one of the customary international law rules, customary private international law rules. Okay, so this is an example for the custom as source of private international law. Also, there is a rule which says that procedures of pleading undergo the law of the judge. يعني قواعد الإجراءات، القواعد الإجرائية في الترافع وفي تقديم الأدلة وإلى آخره، لأي قانون تتبع؟ لقانون دولة القاضي. يعني if there is conflict of jurisdictions between the French court and the Egyptian court and we solve this يعني قواعد الإسناد اللي احنا حندرسها فيما بعد في الفصل الثاني أشارت إلى تطبيق القانون المصري. Okay, so what according to which procedures shall the court work? I mean the Egyptian court work. The court shall work according to the Egyptian law, simply because there is a rule which says that the procedures of the pleading shall undergo the law of the judge. Since the judge is an Egyptian one, then the judge will work according to the Egyptian procedures of the pleading. هيجي واحد يقول لي طب ما هو يعني شيء منطقي، يعني ما دام القاضي مصري إذا لازم يطبق الإجراءات تبعت القاضي المصري. أوكي، يعني هو مش بالساهل إنه أنت توصل لهذه القناعة، لأنه في زمان كان في سابق عهد القانون الدولي الخاص كان ممكن يكون القاضي من جنسية، لكن الإجراءات المتخذة في المحكمة متبعة وفق قانون دولة ثانية. كانت قواعد الإسناد تشير إلى تطبيق إجراءات تابعة لدولة ثانية وفق قانون آخر، لكن القاضي مصري وبيعمل بإجراءات أخرى. لكن اليوم صار في قاعدة عرفية إنه no, the procedures of the pleading shall undergo the law of the judge. It is one of the customary rules of private international law. Also, the real estate undergo the law of its position. العقار والتصرفات الواردة عليه بيحكمها قانون مكان العقار. So if the real estate is found on Syria, then the Syrian law shall apply in this case. Even if the parties to this relation, I mean the seller and the buyer, belong to another nationalities. The law of the law of the position of the real estate shall undergo the matter which relates this estate or real estate. Okay, so this is regarding actually the second source of private international law. Let me move to another source of private international law, which is the International Judiciary. Well, actually, the International Judiciary actually is considered one of the private international law matters. The sources. So the state or the statute, of the ICJ, the International Court of Justice, it stipulates in Article 34, paragraph 1 that only states may be parties in cases before the court. So the statute of the ICJ stipulates that only states may be parties in cases before the court. يعني الحكم اللي صدر عن القضاء الدولي كان بيقول انه الاي سي جي او عفوا الماده 34 لما عددت لي مصادر القانون الدولي العام اللي ممكن المحكمه تحكم بموجبها، بعد هيك حددت لي مين اللي ممكن يكونوا اطراف امام المحكمه، فقالت لي انه الاطراف اللي بيكونوا امام المحكمه only the states. اوكي، هذا امام مين؟ محكمه العدل الدوليه. Since conflict of private international law now they arise between individuals at the first place, these are not allowed to bring cases before the ICJ. احنا الان نتكلم عن الانترناشونال جوديشيري، القضاء الدولي كمصدر من مصادر القانون الدولي الخاص. عشان هيك ما تروحش تدور على شغلات متعلقه بالقانون الدولي الخاص في احكام محكمه العدل الدوليه، لانه محكمه العدل الدوليه متاح بس للستيتس انه يكونوا اطراف فيها. عشان هيك نادر جدا انك تلاقي قضايا امام الاي سي جي بتخص البرايفت انترناشونال لو، لانه مسائل البرايفت انترناشونال لو is between individuals. That's why it is rare to find a case brought before the ICJ regarding one of the subject matters of private international law. Okay, however, we can find a few number of cases related to subject matters of private international law that are brought before the ICJ. So how does that happen? It happens because the states may agree on filing a case on behalf of their subjects before the ICJ. That's why this source, I mean the International Judiciary, is rare, but it's not not invaluable. Okay, so this source is rare but not invaluable, because it may that we find some decisions made by the ICJ regarding the nationality, regarding the, for example, the conflict of laws. But these cases are not brought by the individuals themselves. However, they are brought by the states on behalf of the individuals or their subjects، يعني بالنيابة عن رعايا هذه الدولة. So, however, the ICJ issued many decisions that are important in the field of private international law, like in the matter of the nationality, conflict of laws, and conflict of jurisdictions. عشان هيك بتلاقوا ممكن تلاقوا أحكام في محكمة العدل الدولية بتخص قضايا القانون الدولي الخاص، لكن لن تجدوها صراحة يعني مرفوعة من الأشخاص أنفسهم، وإنما الدول بترفعها بالنيابة عن هذول الأفراد. وإن وجدتوا يعني أحكام متعلقة بالآي سي جي في هذا المجال، في مجال البرايفت انترناشونال لو، حتكون أحكام نادرة جدا جدا. أوكي. International jurisprudence as source of private international law. The German, the Italian, the French, and the Dutch schools of law played a vital role in shaping and developing rules of private international law. تحديدا the Dutch school، المدرسة الهولندية جماعة لعبت دور كبير في تطوير قواعد القانون الدولي الخاص. كانوا كثير الفقهاء مهتمين بهذا المجال. Savini, as one of the jurists of private international law, is an example for jurists of the German legal scholars who played a vital role actually in this regard. So I quote something here from a source. It's a legacy of Friedrich Karl von Savini، الإرث التاريخي تبع الفقيه سافيني، واللي طبعا كتبته كارولين دوبي، associate editor on International Judicial Monitor. If you open this hyperlink, you will find this quotation. The 19th century was a watershed. طلع كلمة watershed اللي هي مركز توزيع مياه، لكن احنا مستخدمينها انه يعني للدلالة على انه كانت مركز انتشار لفكر in development of private international law, as jurists and scholars begin to challenge centuries-old concepts on of how to deal with the confusing legal problems associated with a choice of the law in international disputes. هذه choice of the law يعني بتكلم عن conflict of laws في international disputes. Well, so all you have to know is that the international jurisprudence يعني is considered one of the sources of private international law. Well, the national sources now, the national sources for private international law. طبعا القانون الدولي الخاص له مصادر زي ما احنا حكينا دولية، اللي هي طبعا التريتيز، الكاستمز، والانترناشونال جوديشيري، زائد الانترناشونال جوريسبرودنس، وله مصادر محلية للقانون الدولي الخاص. وهذا أمر طبيعي لأنه قلنا إنه البرايفت international law is a national law despite the fact that it is labeled with the word international. And I have told you before what is the reason that we use the word international. Anyway, the national sources of private international law are the same as the national law sources. What are the sources of the national law? The legislation, the custom, the Islamic Sharia, the natural law and rules of equity. وحقيقة هذه المصادر بتدرسوها بالتفصيل أكثر في الكورس اللي اسمه Private International Law Part 2. You will study the national sources in more details. Anyway, states may promulgate an independent code for matters of private international law, like the nationality laws, or it may put some regulating provisions within the most known code, like the civil code procedures. يعني ممكن الدولة تحط تشريع كامل بيتحدث عن واحدة من مسائل القانون الدولي الخاصة، وغالبا هذا مثاله the laws of nationalities، قوانين الجنسية غالبا بيكون لها قانون خاص فيها بيصدر. واحيانا ممكن القانون او المشرع الداخلي يشرع نصوص متعلقه بمسائل القانون الدولي الخاص ضمن قوانين موجوده فعليا بس مش القوانين كلها، يعني القانون مش كله مخصص للبرايفت انترناشونال لو، وإنما بيشتمل على بعض النصوص المتعلقة بالبرايفت انترناشونال لو، زي السيفل والسيفل بروسيجرز كود، زي القانون المدني وقانون المرافعات. قبل شوي حكيت لكم عن اللوكاس ريجيت اكتوم، انه المكان بيحكم اللي هو المكان يحكم التصرف. بعض التشريعات، نادر طبعا، كانت قد دونت هذه القاعدة وحطوها ضمن القانون اللي اسمه Civil Procedures Codes، وذات الأمر بينطبق على القاعدة تبعت قواعد الإجراء تخضع لقانون القاضي، وذات الأمر أيضا بالنسبة لموطن العقد بيحكم العقد، أو قانون موطن العقد بيحكم العقد. فهذه قواعد دونت في بعض التشريعات ضمن Civil Procedures Code. Okay, so in Palestine, for example, rules on conflict of laws are regulated in the articles 14 to 37 of the Palestinian Civil Code, number 4 of 2012. Some rules actually regarding conflict of jurisdictions. Rules of this subject matter, I mean the conflict of jurisdictions, are adopted by the Palestinian law of the civil and commercial procedures. However, there are independent legislations regarding the nationality. موضوع الناشوناليتي عندنا في فلسطين is a thorny matter. We have different laws of nationalities, and this is because the stages that Palestine underwent. Simply there was the British mandate, or before it there was the Ottoman mandate, or the Ottoman phase, then the British mandate, then the Israeli occupation, and then the Palestinian National Authority. And each stage of these stages there was a law of nationality. That's why the nationality is a complicated matter regarding the Palestinian situation, and we will discuss this in more details inshallah in the coming lectures. So these are examples for the independent legislations regarding the nationality. The Palestinian Citizen Order 1925 was a law of mandatory Palestine that created the Palestinian citizenship for residents of the territory of Palestine mandate. Then it was announced on 24 July 1925 and came into force on August 1925. احنا بنسميها المراسيم الاشتراعية تبعت الجنسية، وحنتحدث عنها بالتفصيل لاحقا. The order remained in effect until 14 May 1984، اللي هو الزمن اللي صارت فيه اللي هو when the British mandate withdrew from Palestine and the Palestinian citizenship came to an end. بعدين Israel enacted a citizenship law in 1952, while the West Bank residents came under the Jordan's nationality law. This will be discussed in more details inshallah in the coming lecture, so you just skip this slide. In the coming lecture inshallah we will start talking about the nationality according to the Palestinian and comparative law. So we will start with an overview, then we will discuss the matters of the nationality in more details. Thank you for being patient. Thank you for your listening. And inshallah, I will see you in another lecture, inshallah, in the coming future. Thank you very much and goodbye.